Good morning. I'm Mahesh Menon. I'm Assistant Professor of Law at the West Bengal National University of Juridical Sciences. And today we'll be talking about the human rights of indigenous peoples. Well, in this course, I'll give you a background towards of who the indigenous people are and what are the principal set of human rights issues that they're facing right now. After that, I'll be talking about what is the definition of indigenous peoples, and then we'll talk about the legal framework, and then I'll leave you with a couple of points to ponder about. The objectives of this course is to expose all students to the human rights challenges faced by the indigenous people and the international legal normative framework for the protection of their rights. Once you successfully complete this course, you should have developed an understanding of the concept of what is indigenous peoples, how the law has defined the category, and what are the limitations of this definitional approach. You should have also understood what are the current conditions of the indigenous people and what are the principal set of human rights abuses that they are facing around the world. And finally, you should have also developed a critical understanding of the international legal framework, which is for the protection of the indigenous peoples. The prerequisites for taking this course is firstly have a fairly strong background in international law and a good exposure to existing international human rights law, and an elementary knowledge of intellectual property law would also be helpful. So let's start with the course now. First of all, let's try and understand who are indigenous peoples. Indigenous is derived from Latin and it means native or original inhabitant. So in common parlance, the expression signifies groups or groups of people who have lived in a particular territory before the arrival of outsiders. And by outsiders, I mean colonizers. The problem of understanding indigenous with this expression or with this concept is that there are a large number of groups of people whom you tend to leave out. For example, this understanding of indigenous would fit classically into almost all of the northern countries like United States of America, Canada, large parts of Latin America, and even Australia, where there were indigenous inhabitants who were living there before the arrival of the European colonizers. However, when you try to apply this definition into, or this concept into, say, the Asian situation or the African situation, which has had very complex histories of migrations, which has lasted for a long number of years, we run into trouble. Because who is actually indigenous, say, in a country like India? Nearly all groups of populations, or nearly everyone, can claim an indigenous status. There's no way of distinguishing between an indigenous person and a non-indigenous person in the post-colonial India. For this reason, often a large number of people who would have gotten the benefit of this legal framework have been excluded because of this approach of defining people as indigenous, that is, a native or an inhabitant who was living in a place before the arrival of colonizers. Nevertheless, there has been a large number of attempts to define who the indigenous people are in international law. The first attempt to define, you will find that in ILO Convention number 107 of 1957, which has a definition that was articulated. And roundabout at the same time, a couple of years later, the UN Special Rapporteur to the Subcommission on Prevention of Discrimination and Protection of Minorities have also made an attempt to define. Both these definitions have looked at a couple of apparently objective criteria, such as cultural differences, the non-dominance, and most importantly, the idea of people who are at a less advanced stage of development. But there are plenty of issues with these definitions. Firstly, as I was telling you a little while back, these definitions have really excluded the tribes of Asia and African region, because trying to find out cultural differences between the tribes and the non-tribal population is a bit hard in both these contexts. Especially in Africa, the word tribe doesn't make is of very limited sense because just about everyone belongs to some tribe or the other. Non-dominance is also a little problematic in both the Asian and the African context because there are large groups of populations who are not in the dominating position. For this reason, both these definitions would have perfectly fit into the United States or Australia or the Canadian experience, but not into Asia and Africa. It's surprising to note then, or maybe it's not surprising to note then, that most of the governments in the Asian and the African regions actually supported these definitions, because by virtue of these definitions, they could exclude a large number of people who should have otherwise belonged, who should have otherwise gotten the benefit of this legal framework. For this reason, both these definitions are now understood to be improper. And more importantly, when you lose an expression like less advanced stage of development in a definition, it's important to remember that you've already passed certain value judgments. Development at the end of the day can be a very contested concept, and when you try to understand a group of people as less advanced or less developed than you are, you have passed a value judgment about their ways of life, and very often this value judgment and this definition can form the basis of certain kinds of action that will destroy their culture and their ways of living. And so, in response to these definitions, the indigenous peoples started claiming a right of self-identification, which means that the power or the ability to define who is indigenous must be left to the people themselves. The idea of self-identification, that a group will identify themselves as indigenous. However, governments have refused to completely recognize self-identification as the sole basis on which indigenous status can be determined. If you look at the ILO Convention of 1957, there is no reference at all to self-identification. However, if you look at the subsequent laws, that is the ILO Convention number 169 of 1989 and the United Nations Declaration on Indigenous People, you will find that there is a reference to self-identification. You will also find that both these instruments say that self-identification must be taken as a category or an important basis on which you determine whether peoples or groups of peoples are indigenous or not. Coming to the ILO Convention number 169 as regards to definition, you'll find that the definition actually obliterates the difference between indigenous and tribal. And this obliteration is very important because you will find that globally the conditions of people whom you call indigenous and people whom you call tribal are more or less similar. But the semantic distinction was used by governments for a very long period of time to deny the rights or the beneficial legal framework to many of the tribal peoples present in their country, and this is especially true of the Asian and African governments. And for this reason, ILO Convention number 169 has taken away this difference and recognized the fact that the beneficiaries of this legal framework are both tribals and indigenous, irrespective of the small semantic differences. Secondly, you can also observe that there are more objective criteria applied. And thirdly, you can also notice this fact that these references to less advanced stage of development or more advanced stage of development have been completely taken away. More importantly, Article 1.2, Clause 2 of the Convention makes self-identification a fundamental criteria in determining the status of indigenous. It's interesting to note that the United Nations Declaration on Indigenous Peoples' Rights, which is a declaration of the General Assembly of the United Nations and the most advanced instrument as far as the rights of indigenous peoples are concerned, do not define the expression. However, Article 8 of this particular declaration makes self-identification a very important criteria based on which you determine the status of indigenousness. Now, the current practice seems to be that, especially at the UN, is to place emphasis on self-identification and try and use it along with other objective criteria. Because it's recognized now that if you try to make a watertight definition, you will not be able to capture the whole variety of indigenous people who live in different parts of the world, who have very different circumstances and very different characteristics. So the current practice at the UN especially is to go as far as possible with self-identification, and secondly, not to get into the semantic exercise between indigenous and tribal. The approach is to look at the living conditions of these people and then try and determine what is the legal status that applies to them. Notably, the World Bank operational policy also does not define the expression, and a strong emphasis is again placed on self-identification. The World Bank Operational Policy 4.0 states that indigenous people may be referred to in different countries by names such as indigenous ethnic minorities, aboriginals, hill people, minority nationalities, scheduled tribes, or tribal groups. These are the different kind of words by which expressions that are now used to connote the indigenous people. And the World Bank Operational Policy actually takes a very practical approach in suggesting that these are the common expressions used, and we mean those particular set of people who are at a disadvantaged position, who have self-identified themselves as indigenous and who require the protection of this legal framework. Now let's talk about some of the challenges faced by the indigenous peoples. Well, in the past and in the present, you will find a certain kind of continuities in their historic experiences. The most important set of issues or abuses that they have faced is, first of all, exploitation. Exploitation of their labor, exploitation of their land, and exploitation of the natural resources on which they live and which they depended on. Labor exploitation is the most common feature that you will find in almost every part of the world. Indigenous people typically are not well organized politically, are not well organized as trade unions, and so it is easier to exploit them for cheap labor. They are underpaid very often, they are subjected to inhuman conditions of work, and they are also not paid properly very often for the work that they do. They are also exposed to several hazardous kind of working situations. However, more importantly perhaps is the exploitation of their land and natural resources. Most of the indigenous people or tribal people have to depend on land and natural resources around them for their survival. And in the name of development, people from outside or people from the more dominant groups come and settle in their region or drive them out of their lands and natural habitats in order to occupy them and to exploit them. This is typically done for things like mining, for building large dams, for timbering, for logging of woods, and for the exploitation of other forest resources, which is of immense economic gain for the dominant groups. However, all of this happens at the cost of the lives of indigenous people. In the past, another set of things that have happened is extermination of large number of indigenous people by the diseases brought forth by the colonizers. For instance, if you look at the United States of America, the European colonizers, when they arrived in the mainland America, they also brought with them many of the European diseases for which the indigenous people did not have any kind of bodily resistance, which then meant that large number of indigenous peoples of United States of America, whom we call by this name Red Indian, which is not appropriate to be used anymore, many of them were killed by the diseases like smallpox and plague that were brought by the Europeans along with them to the United States of America. Another issue that they faced in the past and they continue to bear the brunt of is the creation of new political boundaries, and you will find this especially true of Africa. If you look at the African map, you will find that the boundaries of the states in Africa are all straight lines. This is because these boundaries were not really established by the Africans themselves but by the Europeans. After the Great Berlin Conference, the Europeans decided that there is no point in fighting over the different territories of Africa, so we will merely cut up the territories amongst ourselves. As a consequence of this, you will find straight lines that do not really reflect the political sentiments or the ethnic sentiments that are on ground. As a consequence of this, members of the same set of tribes or members who should have otherwise belonged to the same communities have now been found in two different countries. They are separated by political boundaries which are artificial as far as they are concerned, and they are subjected to two different kind of legal frameworks, different kind of cultural experiences, and they are not allowed to fulfill their right of self-determination. Closely associated with this is also the problem of the imposition of laws which do not really suit their specific cultural context. Especially, you will find that the colonial settlers and the governments that have taken over after the colonial settlers, they have not been very sensitive to the cultural life or practices of the indigenous people. They were branded as backward, they were branded as uncultured, or they were branded as inferior in their cultural practices, and in the attempts at creating reforms, very often laws and legal framework that did not suit them, that did not reflect their sentiments, were imposed on them. A result of this is the loss of identity in many places, the loss of the existing social organization, and the loss of those methods of traditional political organization that they had followed for generations. And though it might for a moment appear to us that this is good or this is required for the advancement of societies, this has not always been true, because the new political orders that were established were ones that could not really capture their imagination or sentiment, and many often these people could also not understand the new political order that was established on them. By virtue of this fact, the reorganization of powers did not suit that particular community, and you had odd individuals exercising powers against the community, and the breakdown of the political order in those communities. These are the principal set of challenges that are faced by the indigenous people in the past, and at present we need to note that there are additional set of issues such as discrimination and exclusion from political power, typically because they are smaller in number, extreme poverty that you can find across almost all indigenous groups prevalent anywhere in the world, displacement from their natural lands and territories which are caused by developmental initiatives. This has given rise to conflicts within the indigenous people and conflicts between the indigenous people and the outsiders, as you call them. This has also, and then there is displacement caused by other kind of conflicts, political conflicts between countries which will be fought in the territories of the indigenous people, displacement caused due to environmental disasters, displacement caused due to climate change, displacement and other forms of developmental violence. So what we need to underscore is the loss of land and habitat that these people face, and the resultant poverty, the resultant exclusion, and the resultant violation of all the other human rights that they have. Another two important issues that we need to talk about is the misappropriation of cultural goods and traditional knowledge of the indigenous people. Most of the indigenous people have a sea or a wealth of knowledge of the flora and fauna that surrounds them, and the medicinal value of the plants around them. And typically, very often, people from outside would come and steal this knowledge and put it to commercial use without paying them or without giving them a part of the profit that they are making. These things will very well be considered as theft of knowledge. And the loss of traditional ways of life and loss of culture are the other set of issues that we need to be talking about here, which is a very difficult question to answer because firstly, we need to understand that culture is not a static entity, it keeps changing over a period of time. And secondly, there is no particular gain on sticking onto one traditional way of life or one traditional kind of culture. We must leave the possibility open that they will keep adopting to new kind of cultures with more cultural influences. Yet at the same time, it is important for us to remember not to impose the culture of the majority on the indigenous people. Striking a balance is easy in theory but very difficult in practice. We will talk about that more in the course of this presentation. A clash of cultural values is something that is often talked about in the context of indigenous people. The modern liberal set of values that we have articulated for our own societies, which are no doubt fundamental, which are no doubt very important as far as preservation of the human dignity is concerned, may not work too well in the context of certain indigenous people. For instance, we might find it shocking that in certain indigenous people who are in the southern Pacific Ocean bury their people alive right a little before they are about to die. Now, we would consider this to be horrible, we would consider this to be absolutely unacceptable, and we would consider this to be murder. But prominent anthropologists have noted that the old people there actually look forward to this practice because they have a strong belief in their communities that unless this practice is done, they will not be able to move on to the next world. We will, as people who belong to the mainstream, consider this to be a horrible practice and we would look forward to banning it. And we would consider this to be murder which needs to be punished. However, it's quite the opposite as far as those people are concerned because they consider this to be a very important culturally significant practice. It's not easy to come out with straight answers in these kind of situations because there is on one hand our understanding of the human life, its value and its dignity which needs to be protected at all costs, and so a practice of this sort which needs to be stopped. On the other hand, there are also their views or their conception of these practices as essential for the fulfillment of their dignity and to ensure the smooth passage of the soul into the next world. In such circumstances, a one-line answer about we should ban the practice or we should allow the practice is very difficult. Maybe the most reasonable approach to take is to educate these people about how undignified the practice is, and with their conviction and with their after we are able to convince them about it, try and regulate it. Let's now talk about the legal framework for the indigenous people. You can look at the legal framework from two analytical standpoints, one of time and the second one of themes. From the standpoint of time, you can divide the evolution of the legal framework into three. The first phase when you had the ILO work happening at the International Labour Organization. starting from the 1920s and ending in the 80s with some kind of activity starting at the UN. The second phase is exclusively things that happened at the UN, that is between 1980 and 2007, the time when the United Nations Declaration on Indigenous People was adopted by the General Assembly of United Nations. And then you can divide it into the post-2007 developments, that is the post-United Nations Declaration on Indigenous Peoples development. From the standpoint of themes, you can try and group the development of law into three principal headings. First one, the development of the law as regards autonomy and self-determination. Secondly, the development of the law regarding rights over land and natural resources and territory. And thirdly, regarding the development of law over the cultural rights. The important milestones for this is in 1926, when the Convention on Native Labour was adopted by the International Labour Organization. And in 1957, the ILO adopted the Convention number 107, which is the first, perhaps, a comprehensive or relatively comprehensive international treaty framework for the protection of indigenous peoples' rights. In 1982, you had the Working Group on Indigenous Peoples established at the UN, which was the working group which is responsible for the drafting of the United Nations Declaration on Indigenous Peoples. In 1989, you have the ILO Convention number 169, which revised Convention number 107, updated it and made it more in line with the current human rights framework and sentiments. And in 2007, you had the adoption of the United Nations Declaration on Indigenous Peoples. Stage 1 is what I call developments at the ILO. Well, there was the work of the Committee on Native Labour at the ILO, which produced a set of primary conventions or small conventions which deals with labour-related aspects of indigenous people's rights. The ILO Convention number 107 is the first comprehensive international legal instruments on the rights of indigenous peoples. However, now you can find, if you look through the convention, you will find that there are a large number of provisions which are quite beneficial, which actually protect the rights of the indigenous people, especially regarding their lands, especially regarding their right to life and dignity. However, the minus point about the convention and what made the convention a bad piece of legislation is its emphasis on national interests, national laws and interests of the majority, which were given primacy over the rights of the indigenous people. And the other thing is that the 107 Convention had a strong integrationist approach. The purpose of the 107 Convention was to integrate those people who were then considered to be culturally backward into the national mainstream, and very violent methods and very unfortunate methods were used for this purpose at times to integrate them forcibly into the mainstream. For this reason, advocates of human rights and the indigenous people themselves completely rejected the 107 Convention, and they asked for a new legal framework which was responsive to their needs. The international movements of indigenous people, which were supported by the activists and NGOs and a large number of academics, resulted in global attention to these issues, and so the United Nations created a working group on indigenous people. And one of the mandates of the working group was to create a document which codified the rights of the indigenous people. Now, what is important about this working group is that they actually worked with an active participation of the indigenous persons' representatives. So for the first time in the history of the United Nations, they were drafting a legal instrument with the active participation of the beneficiaries of that legal framework. And the method that the working group adopted was to ensure that the text of the draft and the text of the draft declaration was consented to by the indigenous people too. Because of this, because of the large number of inputs from the indigenous peoples, the declaration in its final outcome turned out to be the most comprehensive document on the rights of indigenous people. Now, what you should also remember is that because of these activities at the UN, there was a lot of pressure on the ILO also to revise their convention. And you will find that the 107 Convention was revised by the International Labour Organization because of these developments that were happening at the UN. If you compare and contrast the 107 Convention and the 169 Convention, you will find that there has been a sea change. Convention number 169 uses the expression peoples, and 107 does not use the word peoples. This means that 169 is perhaps referring to the idea of self-determination of indigenous peoples. The United Nations Declaration also uses the word peoples, and it is more explicit in the idea of self-determination. However, you must remember that self-determination in both these contexts means a little different from the self-determination that you otherwise use in the case of all the other set of peoples. James Anaya, a very prominent scholar on the rights of indigenous peoples, has explained this and expounded the meaning of self-determination in the context of indigenous people as having a different connotation. It says that freely determining their political status means to have a governing institutional order that has been developed or that is being developed with the participation and accession of the people who are governed, and an ongoing element which means that the governing order must be a one that people can live in, progressive, freely within, or on an evolving basis. This means fundamentally that self-determination in the context of indigenous people does not mean a right of secession which might be there available in the other cases. Self-determination in the context of indigenous peoples only mean to have autonomy within their limited sphere, and to have autonomy for as much as possible spheres of life, and to ensure that they have a large amount of discretion for deciding the way in which they should lead their lives, their legal framework, and their political organization. If you look at Article 20, 23 on 34 of the United Nations Declaration on Indigenous People, you will understand what is the meaning of self-determination and autonomy within the context of indigenous people. And 169 Convention also embodies within it a concept of autonomy, definitely not as wide and great as what the declaration suggests. Nevertheless, it is quite important. Now, if you look at the lands of rights and natural territories, 169 Convention and the Declaration are very explicit, and they provide a large framework for the protection of their land rights. There's prohibition of forced removal from their lands, compensation to be given, the right of return, and consultations before their lands are acquired. At the root of all of this is the idea or the requirement of free and prior informed consent, for which a certain number of background requirements are stated out in the law, not really explicit in the Constitution, but stated out through a large number of judicial pronouncements, especially of the Inter-American Court of Human Rights. The other important issues that we need to talk about is the insensitive use of cultural products of indigenous people. For instance, paintings that belong to them, cultural objects that belong to them are often used in context or out of context, insensitive to the way that they would look at it. Many of these uses would actually constitute an infringement of their dignity and an infringement of their religious rights. Another thing that I talked about earlier was the theft of their intellectual property in the form of biopiracy by the large number of pharma companies without paying them any share of the profits. The problem with using the existing intellectual property right framework for this is that it doesn't fit into their concept of rights and duties. Existing intellectual property law is highly individualistic. It looks at innovation, it demands it to be written, and it grants a monopoly of use over a particular person. On the other hand, for the indigenous people, the idea is that this is more of a collective right, and the requirement is not of innovation but to try and be traditional. Most of these are not really written on any formats, and rather than monopoly of use, they prefer sharing of uses. There are a large number of indigenous claims or indigenous people's demands for a separate legal framework that will address these concerns of theirs, and there has been limited legal response to this. For instance, the United Nations Declaration on Indigenous People has a general provision which says that they have a right to maintain, control, protect, and develop their cultural heritage. And then there is Article 8J of the Convention on Biological Diversity, which says that there is a requirement to respect, preserve, and maintain knowledge, innovations, and practices of indigenous people, and encourage equitable sharing of benefits arising from the utilization of such knowledge. So to give you a final overview, between these three instruments, you will find that you have moved on from the integrationist approach to now the idea of autonomy and self-determination. You have also moved on from a complete lack of recognition of cultural rights to a strong recognition of cultural rights over this period of time. The third stage is the use of these declarations and instruments by a large number of national courts and international courts for the purpose of advancing the human rights of indigenous peoples. And there are some scholars who now argue that the provisions of the UNDIP more or less represent customary international law, or several provisions represent customary international law. However, this is a largely contested issue. The other influence of the UNDIP is also that there are other treaty bodies at the UN and other human rights monitoring bodies which are now more sensitive to the rights of the indigenous people, And most of these treaty bodies now use the UNDIP for the purpose of explaining or expanding the other set of rights in these treaties in the context of indigenous people. However, there are some points to ponder that I'd like to leave you with. First of all, will a convention that is strong enough that will embody the provisions of the declaration as binding law will ever be adopted? Would the provisions of the UNDIP ever mature into customary international law? And what are the ways in which the UNDIP can be used to promote the rights of the indigenous people? All of these are points that we need to look forward, and these would be the most important set of issues that will happen that will happen in the context of the legal framework for indigenous people's rights in the coming future. Thank you.